court there was very clear. Until the apex court has pronounced itself on the interrelated issue, say paragraph dealing with others too. Michael Kabaziguruka and Attorney General, as well as ULS and Attorney General, both of which I have cited, remain good law for the present purpose. Mr. Chairman, the law now is as interpreted by the Constitutional Court, but we can't be here to deal with civilians. Even if we want to, we can't. We can't. Unless we are elevating ourselves above the Constitution. If we are, then we can be here. But if we are not elevating ourselves, then we must abide by what those decisions say until there is a contrary decision. There is no, the stay, I'm sure my land friend will refer to it, the stay does not remove the interpretation. The importance of the Constitution, I don't know what words I can use to express how important it is to abide by the Constitution. Mr. Chairman, the question I would like to frame and proposing framed is this: whether in light of the decisions of civilian courts, both the Constitutional Court and the Supreme Court, regarding the trial of civilians in the court martial, the conduct of the General Court Martial as an organ of the UPDF, to try two civilians is consistent with Article 2082, the one on being subordinate to civilian authority, 128(2), Mr. Chairman, 128(2) is that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure the effectiveness of the courts. Effectiveness of the courts includes its judgments being binding, being applicable to everybody until there is a contrary position. Michael Kabaziguruka was decided about 4 or 5 years ago. There has not been a contrary position. I would pray, Mr. Chairman, that that question also be allowed. We had proceedings still in Article 28, 1 on the impartiality, on the nature of the tribunal, and there is a question that arises about how impartial tribunal, an organ of the defense forces which investigates an offense, charges the accused, tries the accused, can be considered impartial in any way. And this is not to say anything about the character of the fine officers and men who constitute the court. It has nothing to do with their individual, it's the institution. how can you be a judge in your own cause? What? How else can you find prejudice other than being a judge in your own cause? The charge sheet tells us about offences relating to the defense procedure. The defense procedure. So when we ask that these matters move away from here and go elsewhere, we are simply following what the Constitution requires. Yesterday we had engagement, we had this engagement with the judge advocate, a good friend. But from this side and that side, we're always having contestations. Just for purposes of impartiality, the panel, and also yesterday we went through what the panel consists of. But we found a regulation, this is just an example, Regulation 69. So yesterday we had an issue around the judge and whether his views are binding or not, the advice given and so on. I'll address that shortly. But there is also another one which I want to give by example. 69.2 says that a court may adjourn, it is referring to the court martial, may adjourn at any time to consult the convening authority on a point of law. This court is supposed to be complete as a unit, discharging its work alone. Everybody who is a member of this court should be in the court. I checked on who the convening authority is. It's the High Court. Now, if a court will adjourn or can adjourn, is empowered to adjourn, is allowed to adjourn to court, consult the High Command. Mr. Chair, Article 28.1 would have no place. But this regulation cannot apply above Article 28. Impartiality. So, we also pose this question. In the circumstances